The first thing Judge Lena Whitaker noticed was that Officer Grant never asked for her license. He stood beside the driver's window of her silver sedan in the grocery store parking lot while his partner circled toward the passenger side. Lena, a 52-year-old black woman with close-cropped natural hair and a charcoal coat folded beside her, had been backing out when their cruiser blocked her path. Grant said someone had reported a vehicle matching this description near a pharmacy burglary 2 blocks away. He had not looked at the plate before ordering her out. My license is in my purse, Lena said. If you're stopping me, I'd like to know the specific basis. Grant glanced over the grocery bags in back, then at the leather folder on the passenger floor. We'll get to that. Step out first. His tone had the polished patience of someone who had already decided that questions were resistance. Across the hood, Officer Mason opened the passenger door without asking. A teenage cart attendant paused beneath the awning. His carts rattling to a stop, she stepped out. I do not consent to a search, and I'm not interfering with whatever lawful check you need to make. Grant gave a small nod. Good. Keep it that way. That phrase bothered her more than the cold. Lena had spent 23 years listening for the distance between what people claimed to be doing and what their words showed they had already assumed. She did not tell him what she did for a living. Her right to be treated lawfully did not depend on the title stamped inside the court identification card zipped into her purse. Mason leaned into the passenger compartment. His shoulder blocked Lena's view for several seconds. Then he straightened and looked at Grant. The two men exchanged something too brief to be called a conversation. Grant walked around the hood and bent toward the open door. What are you doing? Lena asked, checking the area within reach of the driver. You removed me from the vehicle. Grant did not answer. Mason shifted a grocery bag on the rear seat. Lena heard a jar knock against the door panel. Anger rose fast enough to move her weight forward, but she stopped. The cart attendant was still watching. So was an older woman loading a minivan 3 spaces away. A minute later, Grant emerged, holding a small, clear bag between 2 gloved fingers. White tablets sat inside the plastic. You want to tell me about these? He asked. No, Lena said. Because they are not mine. Mason gave a short breath through his nose. Everybody says that. Lena looked from the bag to the passenger seat, reconstructing what she had seen. Mason's body blocking the doorway, his right hand low near the seat rail. Grant moving only after the glance between them. She had no proof yet, only sequence, and sequence was not enough. Where exactly did you find it? Grant pointed toward the floorboard. Under the front passenger seat. That's not where your partner was reaching when I could still see his hand. For the first time, Mason looked directly at her. Mom, you need to be careful. With what? With how you're characterizing things. The cart attendant took 1 step closer, then stopped when Grant noticed him. Lena saw the boy lower his phone, not quite hiding it. That was the first thing in the parking lot that felt less fragile than her own word against 2 uniforms. Grant told Mason to run her name. Only then did he ask for identification. Lena nodded toward her purse. My driver's license is in the outer pocket. He retrieved that, nothing else. Mason opened the purse and found the license first. Beneath it sat a black court credential. His thumb paused on the gold seal before he pushed it back into place. Grant did not see it. He was already telling dispatch they had probable cause to detain the driver pending a narcotics check. Lena looked at the bag in his hand, then at the patrol number printed above the cruiser's rear wheel. The number was familiar. At 9 the next morning, in courtroom 4B, she was scheduled to preside over a suppression hearing in a felony case built partly on Officer Grant's sworn search affidavit. She said nothing about that. Instructed Lena to place her hands behind her back while Mason read the standard warning from a laminated card he kept clipped inside his vest. The cart attendant had moved closer to the store entrance, but Lena could still see the phone in his hand. Told dispatch that the driver had been uncooperative during a narcotics investigation, although Lena had followed every physical instruction he had given. When she asked him to state what she had done that he considered uncooperative, he tightened 1 cuff and said, You've challenged every step of the stop. That isn't the same thing, Lena said. Mason opened the rear door of the cruiser. Sort that out downtown. Before getting in, Lena asked Grant to preserve every recording associated with the stop. Cruiser video, body cameras, dispatch audio, automated plate reader records, and the parking lot surveillance footage they had already passed twice. Grant stared at her for a moment before writing something in his notebook. He did not acknowledge the request. Mason did. "You can make all the requests you want after processing, Stephen," he said, though the muscles around his mouth had tightened since he had seen the court credential. The cart attendant approached while Grant photographed the plastic bag on the cruiser hood. He looked no older than 17. "Officer, I saw something," he said, voice uneven. Grant turned before the boy could finish and told him to remain out of the investigation. The boy stopped, glanced toward Lena through the cruiser window, then backed away. He did not argue. He simply slipped his phone into the front pocket of his grocery store vest and walked inside. At the district station, Sergeant Colin Pierce accepted Grant's account before speaking to Lena. Grant described a suspicious vehicle, evasive answers, and contraband discovered during a protective search. The phrase protective search appeared twice in his preliminary report, although Lena had been standing several feet from the sedan when Mason reached beneath the passenger seat. Pierce asked no questions about that sequence. He read Grant's summary, looked through the glass partition at Lena, and said, "If she had simply let you establish what was going on, this probably wouldn't have escalated." Lena heard him through the open office door. "Sergeant, I'd like that statement included in whatever supervisory review is created tonight." Pierce stepped into the processing area. "What statement?" "The one you just made before interviewing me." Expression shifted. "Not embarrassment, exactly. Calculation. You're making this harder than it needs to be. I'm asking you to document what you're already doing." Pierce finally requested her identification. Mason handed him the license and the credential he had avoided mentioning in the parking lot. Pierce looked at the seal, then at Lena, then back at the card. His chair gave a faint hydraulic squeak as he sat straighter. "Whitaker?" Lena said yes. Grant, standing near the report terminal, stopped typing. Pierce lowered his voice. "Why didn't you tell them? Would it have changed whether the search was lawful?" No one answered. The station's evidence refrigerator kicked on behind the property counter, a low mechanical hum that seemed louder once the room stopped pretending this was routine. Lena watched Pierce place her credential beside the report, instead of immediately returning it. He now knew who she was, but the problem had begun before he knew, and she intended to keep that distinction intact. Grant recovered first. He told Pierce that her occupation made no difference, and that the evidence spoke for itself. Lena agreed, and preserve all of it. Pierce ordered Mason to upload the body camera files before the end of shift. Mason looked down at his vest. "Mine cut out for a few minutes." "When?" Lena asked. Mason looked at Pierce rather than at her. "Battery issue." Grant said his camera had been active. That gave Lena her second clue. At the parking lot, Grant had stood outside the passenger door while Mason's body blocked the search. If Grant's camera remained active, its angle might show Mason's shoulders, his hands, or at least the timing of the discovery. If it did not, the missing view would have to match both officers' written accounts. Pierce told Lena the tablets would be submitted for laboratory identification and that prosecutors would decide whether charges were appropriate. Because the suspected substance had not yet been confirmed and she had established residence, he authorized her release after processing rather than continued detention. Her car, however, would remain impounded under the department's evidence policy. The inconvenience was real. Her robe, case files, and medication for the next morning were inside a vehicle she could no longer access. Just before midnight, Lena stepped outside with a property receipt and no coat. Her sister was driving across town to pick her up when the grocery store cart attendant emerged from the station lobby behind her with his mother. He did not approach Lena. He went directly to the front desk. "I need to make a witness statement," he said. "And I already copied the video somewhere. They can't take it." Behind the glass, Sergeant Pierce looked toward Grant's unfinished report. The version of the stop that had been official for less than 2 hours had just acquired its first contradiction. The witness statement took 43 minutes because the cart attendant, Noah Reed, kept stopping to separate what he had seen from what he thought it meant. Lena respected that. He did not claim he had watched Mason place the bag under the seat. From his angle beneath the store awning, he had seen Mason approach the passenger side with one hand closed around something small, then lean into the car while Grant kept Lena facing the opposite direction. His phone video captured most of that sequence. though a delivery van crossed the frame for several seconds at exactly the wrong time. Noah's mother refused to let the officers take his phone. "You can copy the file," she said, "but you're not keeping his property unless somebody gives me paperwork." Pierce did not argue. By then, Grant had stopped treating the station as his own ground. He remained near the report terminal, occasionally correcting Mason's description of the stop, and every correction seemed to make Mason less certain of what he remembered. Lena's sister, Renee, arrived shortly after midnight with Lena's spare coat and a look that made clear she had postponed several questions only because strangers were present. In the parking lot, she unlocked her sedan and waited until Lena had fastened the seatbelt. "Tell me one thing," Renee said. "Are you going to work tomorrow?" "That wasn't what I asked." Lena rubbed the faint pressure marks around one wrist. Courtroom 4B was scheduled to hear 6 matters before lunch, including the suppression hearing in which Grant was listed as the primary officer. She had already understood the consequence the moment Pierce spoke her name aloud at the station. She could not sit in judgment of an officer whose conduct she now personally disputed, even if the pending case had nothing to do with her detention. "I'll go in," she said. "I won't hear his case." Renee pulled away from the curb. "Good, because for about 10 seconds I thought you were about to tell me being fair meant pretending tonight didn't happen." The remark irritated Lena because it found the exact argument she had been making privately. By the time they reached her house, she had drafted an email in her head to the presiding judge, disclosing the encounter and requesting reassignment of every matter in which Grant or Mason was a material witness until the conflict could be reviewed. It meant giving up control of a case she had studied for 2 weeks. It also meant creating a record before either officer could decide her silence was useful. At 7:18 the next morning, Lena sent the disclosure from her kitchen table. She included no accusation that the officers had planted evidence. She stated only verified facts. She had been detained, her vehicle searched, suspected contraband attributed to her, and both officers were now connected to a matter pending before her. She requested immediate reassignment and asked that the clerk preserve the original hearing calendar. The presiding judge called 12 minutes later. "You did the right thing," he said. "The Grant matter is moving to Judge Alvarez." Lena looked at the mug Renee had left beside the sink. "There's another issue." She explained that Grant's affidavit in the pending case described a roadside search using language strikingly similar to what he had written about Lena's stop. Suspicious behavior, officer safety concerns, limited protective access, contraband discovered near a passenger seat. Similar wording proved nothing by itself. Police reports often shared standard language, but now that Lena had become part of an investigation involving Grant, she could not ethically examine whether the resemblance mattered. Judge Alvarez would have to decide that. 9 o'clock. Lena entered the courthouse through the employee entrance without her robe. Her sedan was still in the impound lot, along with the garment bag she normally carried upstairs. A court security officer handed her a temporary access badge because her credential remained logged as property at the station. The cheap plastic clip pulled awkwardly against her blouse. She almost laughed at the absurdity of needing temporary identification inside a building where her name was engraved beside the courtroom door. Lasted until the clerk met her in chambers. "Internal Affairs called," the clerk said. "They want you to submit a formal complaint before noon." Lena set her briefcase down. "Of course they do," and Judge Alvarez postponed Grant's hearing. That stopped her. Why? The defense filed a preservation motion this morning. He heard about an allegation involving him and asked for all recent body camera uploads before proceeding. Lena felt the first real cost of the night settle into place. Her case had not stayed confined to a parking lot. Grant's credibility now touched another defendant, another search, another court record. She had wanted evidence preserved because she feared what had happened to her could disappear. Preservation had done something larger. It had prevented the institution from treating her stop as an isolated inconvenience. 9:27, the police department placed Grant and Mason on administrative duty pending review of the witness video, body camera files, and the chain of custody record for the bag recovered from Lena's car. Grant had believed the handcuffs made his version official. Instead, the official record had become the one thing he could no longer control. At 9:41, Lena learned that administrative duty did not mean the investigation had chosen a side. Internal Affairs wanted her statement, the witness video, the officer's camera files, the station intake log, and the evidence property record. A. The investigator assigned to take her complaint warned that the review could take weeks. Lena understood the caution, but the timeline scraped against her nerves. Grant and Mason had been able to write their version within hours. Correcting it would require signatures, exports, interviews, laboratory testing, and people willing to admit what they had failed to question. She spent the next hour dictating facts in chambers instead of hearing cases. The court administrator reassigned her morning docket, then asked whether she wanted the afternoon matters covered as well. Lena said no too quickly. "I can work." The administrator reminded her that sleep deprivation and an active misconduct complaint were not character tests. Lena heard the concern as doubt and answered more sharply than she intended. "I know what I'm capable of." When the administrator left, she stared at the closed door and realized she had just punished someone for offering the kind of care she wished the officers had shown basic strangers. Nay called. During the recess she no longer needed. "Come home after lunch," she said. "You were handcuffed 6 hours ago. I have 2 sentencing matters that have nothing to do with them. That is not the point." Lena nearly told her sister she could not afford to look shaken, then stopped. That sentence belonged to an older wound, one she had carried since her first years on the bench. When a senior lawyer had advised her that a black woman in authority was allowed fewer visible mistakes than everyone around her. She had built discipline from that warning, until discipline sometimes became refusal. "No. I'll finish the matters already prepared," she said. "Then I'll leave." Renee sighed. "That's not what I wanted, but at least it's a negotiation." The Internal Affairs investigator arrived just before noon carrying printed system logs rather than questions alone. Grant's body camera had remained active throughout the parking lot stop. Mason's file, however, contained a gap of 4 minutes and 12 seconds beginning 38 seconds before he opened Lena's passenger door. The device had not lost power. Its diagnostic record showed a manual deactivation followed by a manual restart. "That proves he turned it off," Lena said. "It proves the camera was manually stopped," the investigator corrected. "Why is still an open question," Lena nodded. She appreciated the distinction even though part of her wanted the cleaner answer. Noah's video showed Mason approaching the car with his right hand closed, but the delivery van blocked the critical seconds near the passenger door. Grant's body camera captured Mason's back, Grant's instructions, and Lena's objections. It did not show what was under the seat before Mason reached inside. None of the recordings by themselves proved planting. The third clue came from the evidence property record. The clear bag recovered from Lena's sedan had been assigned a temporary item number at the scene, but the number entered into the station system belonged to a narcotic seizure from Grant and Mason's previous shift. That earlier item had been listed as destroyed after field testing, showed no controlled substance. The investigator cautioned that duplicate numbers could result from clerical error, especially when officers created handwritten temporary tags before formal intake. "Then compare the handwriting, timestamps, and property room access," Lena said. "And the earlier seizure? Preserved now." That answer changed the shape of the problem. Lena had expected to defend herself against an invented possession allegation. A recycled item number created a different possibility, not yet proof of misconduct, but a reason to examine whether evidence handling around the 2 officers had broken down before her stop. She thought of Grant's pending affidavit in the reassigned case and felt an impulse to ask what investigators had found there. She did not. That case was no longer hers. By early afternoon, the suspected tablets from Lena's car had tested negative in the department's preliminary analysis. They were over-the-counter antihistamines, unmarked and loose enough to justify laboratory confirmation, but not the narcotics Grant had suggested in his radio call. Lena expected relief. What came instead was fatigue so sudden she had to sit before signing her complaint. The investigator closed the folder. "This removes 1 allegation against you. It does not answer how the bag got there." Lena looked at the temporary courthouse badge clipped to her blouse. "I know." Before leaving, the investigator added one more fact. The preservation order filed that morning had uncovered 3 recent defense requests involving searches documented by Grant. 2 described body camera interruptions. One involved a passenger-side discovery made while the driver was already outside the vehicle. Lena did not ask for names or case details. She understood enough. What happened in the grocery store parking lot might still turn out to be one bad stop supported by sloppy evidence handling. But the department could no longer determine that by examining her stop alone. 3 days later, the laboratory confirmed that the tablets from Lena's car contained no controlled substance. By then, the important question had moved beyond what was inside the bag. Internaliers had reconstructed the temporary evidence number and discovered that Grant had written it on his scene envelope 18 minutes before Mason claimed to have found anything beneath Lena's passenger seat. The timestamp came from the department's mobile evidence application, which automatically recorded when an item label was generated. Marisol Vega showed Lena the timeline in a conference room at police headquarters. The label was created at 7:46. Your stop began at 8:04. Lena read the entry twice. Could he have prepared numbers in advance? He could prepare an empty property entry, Vega said. He could not assign that description in advance. The description field read White Tabel TS in clear bag. Grant had entered it while his cruiser was still parked behind a closed pharmacy, finishing paperwork from the officer's previous call. The system had stored the draft locally and synchronized it when the cruiser connected to the station network. It was the first piece of evidence that did more than expose a gap or contradiction. It placed knowledge of the bag in Grant's possession before Lena's car had entered the parking lot. Vega did not call it proof of planting. She explained that Grant could claim he had accidentally reused wording from the prior seizure, and his attorney had already raised that possibility. The earlier property number made the explanation superficially plausible, but investigators had also recovered a photograph from the previous shift. It showed a clear bag containing white antihistamine tablets beside Grant's notebook. The bag's heat-sealed corner had a narrow diagonal crease. The egg taken from Lena's car had the same crease. Lena felt satisfaction arrive and disliked how quickly it came. She had spent years telling jurors and lawyers that resemblance was not identity, suspicion was not proof, and anger did not shorten the distance between them. "You'll need the packaging examined," she said. "It's being done, and chain of custody on the earlier item, already requested." That evening, Renee found Lena at her dining table trying to eat soup while reading nothing. The spoon had gone cold in her hand. Renee took the printed complaint chronology away and set it face down. "You've been staring at the same page since I got here. I'm thinking, you're rehearsing." Lena started to object, then let the sentence go. She had been imagining Grant's explanation, Mason's explanation, the department's explanation, and how each could fail. It was an old professional reflex, useful on the bench and corrosive at home. "I want the answer finished," she admitted. Renee sat across from her. "You don't get to sentence uncertainty." Despite herself, Lena smiled. "That is a terrible legal metaphor. It got you to eat." The next morning brought the deeper problem. Judge Alvarez requested a private administrative conference with the presiding judge, defense counsel, and prosecutors handling Grant's pending suppression case. Lena was not invited, and she did not ask to attend. An hour later, the presiding judge informed her only of what affected court operations. Prosecutors had begun reviewing Grant's recent sworn affidavits because the evidence label timestamp undermined his credibility in any case where the timing of a search mattered. The review did not erase convictions or invalidate every arrest. Each case would require its own facts, but one defendant had already been granted a new suppression hearing after body camera metadata showed that Grant's report described contraband being discovered before the camera recorded the search beginning. Mason's position changed that afternoon. Through counsel, he requested a separate internal affairs interview and offered to provide information about Grant's evidence practices in exchange for no departmental promise beyond an accurate record of his cooperation. He had told Lena only what she was permitted to know. Mason was no longer giving the same account he had signed the night of the stop. The department immediately placed both officers on suspension pending the expanded investigation and notified the prosecutor's professional responsibility unit. No one had been fired, and no criminal charge had been filed. The machinery moved slower than outrage, but it was moving through people who now had records they could test. Before Vega ended the call, she told Lena the packaging examination had come back. The two plastic bags were not merely similar. Microscopic marks along the sealed edge showed they had once been part of the same continuous strip of evidence packaging. For the first time since the parking lot, the question was no longer whether the bag had existed before the search. The question was who had decided Lena's car would become its next location. Mason's second interview began without Lena in the room and ended with enough information to change the investigation. According to the summary Vega was authorized to share, Mason admitted that Grant had carried the antihistamine bag from the earlier pharmacy call into the grocery store stop. Mason claimed he did not know Grant intended to put it in Lena's car until Grant told him, through the open passenger door, to check the rail. He also admitted turning off his body camera because Grant said the stop would be easier without extra noise if Lena became difficult. The admission did not rescue Mason. He had opened Lena's door without consent, blocked the view of the passenger compartment, restarted his camera only after the bag appeared, and signed a report stating he had discovered it during a lawful protective search. Vega made that distinction clear when Lena asked whether cooperation would reduce his consequences. "Cooperation can be considered," she said. "It doesn't rewrite participation." Lena appreciated the answer more than she expected. For several days, she had worried that the investigation might need Mason so badly as a witness that his own choices would become background. She had seen cases where necessity blurred responsibility. This time, the department's written review separated conduct into stages: Grant's preparation of the bag, Mason's camera shutdown and search, Grant's radio statements, both officers' reports, and Pierce's supervisory acceptance of their account before interviewing Lena. Pierce had become part of the inquiry for a different reason. His body-worn microphone at the station had captured Grant telling him, before Lena's credential was revealed, that the stop was clean enough and that Mason's camera problem could be documented as battery failure. Pierce did not challenge the statement. Later, after learning Lena was a judge, he ordered the upload but failed to amend his initial supervisory note, which still described the camera loss as a technical malfunction. His attorney argued that Pierce had been relying on information from subordinate officers. Lena could understand the argument because supervision often required provisional judgments. What she could not overlook was the point at which provisional became convenient. Pierce had possessed the diagnostic upload before signing the report that called the shutdown accidental. That did not make him part of the planting, but it raised a separate question about whether he had protected the officer's version after the data contradicted it. The personal cost arrived that afternoon in a quieter form. The presiding judge informed Lena that, until the department and prosecutor completed their reviews, she would be temporarily reassigned from criminal suppression matters involving city police. No one accused her of wrongdoing. The change protected defendants, officers, and the court from arguments that her experience had compromised her neutrality. Lena knew the reasoning was sound and hated it anyway. She stood alone in courtroom 4B after the last civil hearing, running one finger along the edge of the bench where she usually stacked search warrant motions. She had spent years earning trust precisely because she took conflicts seriously. Now doing the right thing meant surrendering part of the work she valued. When Renee called, Lena nearly said she was fine. Instead, she told her, "I understand the decision. I still resent needing it." "That sounds healthier than pretending you don't," Renee said. 2 days later, the prosecutor's professional responsibility unit completed its first review of Grant's pending cases. It found no basis to assume every arrest was tainted, but 5 searches required additional scrutiny because their reports used the same sequence of officer safety language, followed by discoveries in areas no longer accessible to detained drivers. Defense counsel were notified. Relevant body camera files and evidence logs were placed under preservation orders. Then the packaging analyst delivered the result Vega had been waiting for. The strip marks, cut pattern, and manufacturing seam established that the bag from Lena's car had been separated from the same evidence sleeve photographed during Grant and Mason's earlier pharmacy call. Combined with the mobile evidence timestamp and Mason's revised statement, investigators now had a coherent chain showing the bag existed in police possession before Lena was stopped. Grant was served with a formal notice of misconduct allegations that evening. The notice included evidence fabrication, false reporting, improper search, and interference with recording policy. Mason received allegations for participation, false reporting, and intentional camera deactivation. Pierce was removed from supervisory duty pending a separate integrity review. None of those notices decided guilt. But for the first time, Lena's innocence no longer depended on anyone believing her word over theirs. The department had reconstructed the sequence from records the officers themselves had created. The first formal test of the department's case against Grant happened in a room designed for neither drama nor mercy. A long table, 2 wall clocks that disagreed by 3 minutes, a recorder with a red status light, and 4 binders marked with evidence numbers. Lena was not there. Her role was limited to a sworn statement and whatever questions investigators later sent through counsel. She spent that morning hearing landlord disputes in a temporary civil docket while the disciplinary panel examined the stop that had removed her from criminal work. Vega called during lunch with an update she could legally share. Grant had denied planting anything. His attorney argued that the mobile evidence entry was a copied draft from the earlier pharmacy call, that the packaging similarity reflected standard department supplies, and that Mason had changed his story to protect himself. Grant also claimed Lena's questions during the stop had made the officers concerned she might interfere with a lawful investigation. None of those arguments was frivolous enough to dismiss without testing, which was precisely why the panel had ordered a reconstruction. The reconstruction took place at the grocery store lot using the original cruiser, a department sedan matching Lena's, and officers uninvolved in the case. Investigators measured sight lines from Noah's position beneath the awning, checked what Grant's body camera could capture from the driver's side, and repeated Mason's claimed reach beneath the passenger seat. A seat rail sat low behind a plastic trim panel. To retrieve an object where Mason said he found the bag, an officer had to kneel or lean deeply enough that Grant's camera should have recorded part of the movement. It had not. That absence was not decisive by itself. Bodies shifted. Cameras bounced. A hand could move outside the lens. But the test produced something less ambiguous. Grant's report stated that he saw Mason locate the bag beneath the seat and immediately raise it into view. From Grant's documented position, the seat rail was completely hidden by the passenger door and Mason's torso. Investigators repeated the movement from 3 angles. There was no point at which Grant could have seen what he claimed to have seen without moving around the front of the sedan. His camera showed that he never did. At nearly the same time, technicians completed the comparison of the evidence sleeve. The microscopic seam established common origin. Grant's attorney was correct that common origin did not prove when the smaller bag had been separated. The answer came from an unremarkable pharmacy photograph taken by Mason during the earlier call. A time-stamped image showed the antihistamine bag already cut from the sleeve and resting beside Grant's field notebook more than 20 minutes before Lena entered the grocery lot. When Vega explained the result, Lena was standing beside a courthouse vending machine trying to make a package of almonds fall from a stuck spiral. So the bag was already separate, she said. Yes, and Grant had documented it before the stop. Yes, Lena hit the purchase button again. Nothing moved. Then why did he stop me? That part is still being examined. The answer irritated her because she wanted motive to line up as neatly as timestamps. Later that afternoon, she learned why investigators were resisting that temptation. The original dispatch record contained no report of a silver sedan connected to the pharmacy burglary. Grant had initiated the stop without a matching vehicle alert. His first radio transmission described Lena's car as suspicious because it had circled the lot. But store surveillance showed her entering, shopping for 26 minutes, loading groceries, and backing out once. No circling. No burglary match. The stop had begun with a story created after Grant saw her vehicle, but investigators still could not prove why he chose her. Vega refused to turn inference into fact. Lena found that restraint painful and necessary. That evening, she received a message from the presiding judge. Her temporary reassignment would continue. One of Grant's older cases had produced a genuine controlled substance after a search, and defense counsel was now challenging the report because Grant's credibility had become material. The court could not assume misconduct infected the case, but it also could not ignore the newly documented contradictions. Lena sat in her car, a rental this time, and read the message twice. Her own case was becoming stronger while her professional world became less certain. Justice. She was discovering from the wrong side of the bench, did not move in a straight line toward relief. Every verified fact created another obligation to separate what could be proved from what merely felt obvious. Before she drove home, Vega sent one final update. Noah's original phone video had been enhanced for timing, not imagery. Investigators could not see what Mason carried in his closed hand. They could hear Grant, just before Mason opened the passenger door, say 4 words his report never mentioned. Use the one already logged. The disciplinary hearing resumed the following morning with the 4 words from Noah's recording written across the first page of the investigator's transcript. Grant's attorney challenged the enhancement, arguing that background noise from shopping carts and the patrol radio could have distorted the phrase. The panel did not treat the audio as self-proving. They ordered the original file, compared against Noah's untouched backup and Grant's body camera track, then asked 3 technicians to perform independent waveform and timing reviews. All 3 placed the phrase in the same 7-second window. Grant sat across from the panel while Vega walked through the sequence without adjectives. At 7:46 p.m., he created an evidence entry describing white tablets in a clear bag. At 8:04, he blocked Lena's car. 38 seconds before Mason opened the passenger door, Mason manually stopped his camera. Grant's recording then captured him saying, "Use the one already logged." Minutes later, the bag appeared beneath Lena's seat. The packaging matched the earlier pharmacy evidence sleeve, and Grant's report claimed he had witnessed a discovery his documented position made impossible to see. His attorney objected to the final point. Impossible is not the same as unlikely. Vega nodded. That is why we reconstructed it. Video from the reconstruction played on a wall monitor. An investigator stood where Grant had stood. Another copied Mason's position at the passenger door. From that angle, the space beneath the seat disappeared behind Mason's body. The panel watched the demonstration twice. Grant looked down at the binder in front of him and said the officers had been moving faster during the real stop. Vega answered that Grant's own camera established his location throughout the relevant seconds. The panel chair asked the question Lena had wanted answered since the parking lot. Why was Judge Whitaker stopped? Grant said the vehicle had appeared suspicious near the pharmacy call. When reminded that surveillance showed Lena entering the lot once and shopping for 26 minutes, he shifted to officer intuition. Something about the car didn't fit the area. What specifically? Grant hesitated. Behavior. What behavior? He did not answer immediately. The hearing room remained practical rather than theatrical. Paper turned, a recorder clicked, someone adjusted an air vent. Finally, Grant said he had seen Lena watching the cruiser as she loaded groceries. The store footage showed her facing the opposite direction for most of that time. Mason's testimony came next. He admitted that Grant had instructed him to use the bag from the pharmacy call after deciding Lena was probably good for something. Mason said he understood the instruction before he entered the car. His earlier claim that he discovered the bag independently had been false. He also admitted he had turned off his camera because he knew what Grant wanted him to do and did not want the device recording the placement. The panel chair asked why he went along with it. Mason swallowed before answering. Because I'd seen him bend searches before, and nothing happened. I told myself this was just another shortcut until I was already inside the car. That explanation reduced nothing. It did, however, widen the responsibility beyond one officer's impulse. Investigators had already found complaints against Grant alleging aggressive searches, though none had previously established evidence fabrication. 2 had been closed after supervisors accepted his reports over civilian accounts. Pierce had signed one of those closures. By afternoon, the panel issued interim findings. Grant's account was not credible on the material points. Mason's revised statement was corroborated by metadata, packaging analysis, and the recordings, though his initial false report remained part of the misconduct case. Pierce had not participated in planting the bag, but the department found sufficient evidence that he mischaracterized Mason's camera shutdown after receiving contradictory diagnostic data. The chief placed Grant on unpaid suspension pending termination proceedings and referred the evidence fabrication findings to the county prosecutor for independent criminal review. Mason remained suspended pending discipline and the prosecutor's decision about his cooperation. Pierce was removed permanently from field supervision while a broader command review examined his handling of prior complaints. That evening, Whitaker called Lena before the findings became public. "There's something you should know before tomorrow," she said. "The department is moving to void the citation, return your vehicle, reimburse the impound fees, and issue a written correction to the arrest record." Lena looked through her kitchen window at Renee carrying groceries from the driveway. Those remedies mattered. They restored what had been taken from her. But they did not restore the days she had spent wondering whether two officers' version of events would become more durable than the truth. "What about the other cases?" she asked. He paused. "The review is expanding." Lena closed her eyes briefly. Her own stop was finally approaching an answer. The institution's test was only beginning. The written correction reached Lena before the public announcement. It stated that the contraband attributed to her had been placed inside her vehicle by department personnel, and that the resulting detention, search, and impound were unsupported by lawful cause. The citation was voided, the arrest notation removed from the department's active records, and reimbursement authorized for towing, storage, and rental expenses. Lena read the letter twice, not because it was unclear, but because official language looked different when it finally carried the truth instead of requiring her to fight through it. Grant's termination hearing concluded that afternoon. The chief accepted the disciplinary panel's findings that he had fabricated evidence, submitted a false report, conducted an unlawful search, and attempted to conceal the conduct through misleading documentation. His employment ended immediately after the required administrative process. The county prosecutor separately announced that a criminal investigation was underway, making clear that termination was an employment consequence, not a substitute for whatever legal judgment might follow. Mason received a different outcome. His cooperation had helped investigator reconstruct the stop, but the department found that cooperation began only after he had planted the bag, labeled his camera, and signed a false report. He was terminated as well. The prosecutor's office stated that his assistance would be considered in charging decisions, without promising immunity or a particular result. Lena had expected to feel something when she heard both men were gone. Instead, she thought about Noah standing under the grocery store awning, uncertain and 17, trying to describe only what he had actually seen. Pierce was demoted from sergeant and reassigned to a non-supervisory administrative position pending completion of the command review. The finding against him was narrower but still serious. He had accepted Grant's version too readily, failed to reconcile the body camera diagnostic record, and signed a misleading supervisory account after contrary information was available. The chief rejected the argument that Pierce had merely trusted experienced officers. Supervisory trust, the decision stated, did not eliminate the duty to examine contradictions. The department also announced the first operational changes. Any manual deactivation of a body camera during an enforcement encounter would now generate an automatic supervisor alert. Evidence labels created before a recorded recovery would require documented explanation and secondary approval. Complaints involving search chronology would be reviewed against metadata before being closed on conflicting statements alone. None of the changes could guarantee another officer would never lie. They did make lying more difficult to bury inside ordinary paperwork. The cost to Lena did not disappear with the findings. The presiding judge extended her temporary removal from police-related suppression matters until the prosecutor finished reviewing Grant's older cases. "This is not discipline," he told her in chambers. "It is insulation for the court." "I know. You don't sound convinced." "I'm convinced," Lena said. "I'm also allowed to dislike being insulated from work I spent 23 years learning to do." He accepted that without trying to improve it. For once, Lena appreciated a conversation that did not require either person to turn discomfort into wisdom. That evening, she returned to the impound facility to collect her sedan. The evidence seal had been removed from the passenger door, leaving a faint adhesive line along the paint. Inside, the groceries from that night were gone. Her robe remained in its garment bag, and the leather folders still rested on the floor where Mason had first reached into the car. Lena opened the passenger door and stood there longer than she intended. Renee had driven her over and waited beside the rental. You want me to drive yours home?" Lena almost said yes. Then she looked at the driver's seat and realized she did not want her first trip back in the car to happen as a passenger. "No, follow me." Before leaving, she checked the seat rail. Nothing was there except dust and a grocery receipt folded against the carpet. She picked it up, read the date, and remembered what she had been buying before two officers decided her ordinary evening could be rewritten. The receipt listed soup, oranges, coffee, and the cinnamon bread Renee always complained Lena bought too rarely. She slipped it into the center console rather than throwing it away. Across town, the prosecutor's review team was already preparing notices in 5 cases connected to Grant's searches. Lena would not participate in those decisions, and she would not know their outcomes until they reached the public docket. Her own rights had been restored. The officers responsible had faced direct consequences. The harder institutional work now belonged to people who could examine those cases without her experience becoming another disputed fact. She started the engine and adjusted the mirror. For the first time since the stop, the car belonged only to her again. The department's reforms became real 2 weeks later, when an automatic alert flagged a patrol officer who had switched off his body camera during a consent search. The officer had a legitimate reason. The device had overheated and restarted after 90 seconds. Under the old system, the interruption might have lived only inside his report. Under the new one, a supervisor compared the diagnostic log, interviewed the driver, and documented the explanation before closing the review. Lena learned about it from the department's public compliance report, not from anyone calling to reassure her. That mattered. A policy that worked only when a judge was watching would not have been reform. She read the report at her kitchen counter while Renee buttered toast and complained that Lena had somehow turned breakfast into continuing legal education. "You know normal people read the weather," Renee said. "I checked the weather." "When?" "Tuesday." Renee laughed, and Lena did too. The sound surprised her. For weeks, ordinary moments had felt borrowed from the case, as if every grocery bag or patrol cruiser carried another meaning. That morning, toast was only toast until Lena noticed the cinnamon loaf between them and remembered the receipt she had kept in her console. She did not mention it. Some connections did not need testimony. Noah's situation proved harder. After his name became public through the misconduct proceeding, several customers praised him at the grocery store, while others accused him of trying to destroy officers' careers. One afternoon, a man followed him through 2 aisles, calling him a liar until a manager intervened. The store transferred Noah temporarily to morning shifts and arranged for security to walk employees to their cars. The department also provided a formal letter confirming that his video had materially assisted the investigation. Lena sent him no personal note. She worried that anything from a judge could look like influence while related cases remained open. Instead, through the Victim Services Coordinator, she asked whether witness support resources included counseling and legal assistance if harassment escalated. They did. Noah accepted the counseling referral and declined everything else. Pierce faced his own consequence without the clean finality of termination. During the command review, he admitted that he had treated Grant's confidence as a substitute for verification, because Grant had produced arrests supervisors considered productive. He also acknowledged closing an earlier search complaint after comparing written statements but not checking the camera metadata available in the system. 3 complaint files were reopened. Pierce's demotion remained in place, but he was allowed to stay employed after completing remedial training and accepting a permanent bar from supervisory promotion for 3 years. Some officers thought that was too harsh. Others thought he should have been fired. Lena resisted forming a private sentence of her own. His responsibility was real, but it was different from Grant's and Mason's. If accountability could not distinguish degrees of conduct, it became another shortcut. The prosecutor's review of Grant's older cases produced mixed outcomes. 2 searches were upheld after independent evidence confirmed the seizures. In court suppressed narcotics because Grant's report placed a discovery at a time contradicted by body camera metadata. Another defendant received a new hearing after prosecutors disclosed Mason's cooperation statement. No one announced that every case had been corrupted. The record was uglier and more precise than that. That precision slowly changed Lena's relationship to her own anger. She had wanted, at first, one unmistakable answer large enough to explain the whole night. Instead, she received a chain, an unjustified stop, a prepared bag, a disabled camera, a false report, a supervisor who chose convenience, a witness who preserved what he could, and systems that eventually allowed separate people to test separate facts. The chain did not make the humiliation smaller. It made responsibility harder to hide inside a single villain. 6 weeks after the stop, the presiding judge restored Lena to the full criminal docket. Her first suppression matter involved neither Grant nor Mason. She entered courtroom 4B wearing the same robe that had spent a night locked inside her impounded car, then sat while a young defense attorney challenged a search based on an officer's inconsistent timeline. Lena listened without rushing him. When testimony ended, she asked for the body camera metadata before ruling. Outside the courthouse, her silver sedan waited where she had parked it that morning. The adhesive mark on the passenger door had faded, but not disappeared. Lena ran one finger across it before getting in, then left it alone. 3 months after the grocery store stop, the county prosecutor filed criminal charges against Grant for evidence tampering, official misconduct, and filing a false report. Mason entered a cooperation agreement requiring a truthful plea to misconduct connected to the search and testimony subject to cross-examination. The agreement did not erase his firing or guarantee probation. Pierce was not criminally charged. Investigators concluded that his conduct supported administrative discipline and reopened complaint review, but they found insufficient evidence that he knew about the planted bag before Lena arrived at the station. Grant's case never came before Lena. The court administrator assigned it outside her division before the indictment was unsealed, and Lena requested that the recusal remain permanent for every proceeding connected to the incident. Months later, Grant entered a negotiated guilty plea after the defense received the packaging analysis, metadata, Noah's original video, and Mason's testimony. The sentence included incarceration followed by supervised release and a prohibition on law enforcement employment. The judge who imposed it emphasized that the punishment addressed Grant's conduct, not Lena's occupation. Had the driver been a cashier, nurse, mechanic, or unemployed parent, the fabricated evidence would have been the same crime. Mason pleaded guilty separately. His cooperation reduced the prosecutor's sentencing recommendation, but the court rejected his attorney's suggestion that following Grant's lead made him a passive participant. He had switched off his own camera, entered the sedan, helped create the false discovery, and signed his name beneath a story he knew was untrue. His sentence was lighter than Grant's and included community supervision after a shorter custodial term. Noah did not attend either hearing. Through the victim services coordinator, he said he had already spent enough time watching adults explain choices they should not have made. The broader case review closed 11 months after Lena's stop. 5 defendants received new hearings. Evidence was suppressed in 2 matters where search records could not survive independent scrutiny. Another conviction remained intact because separate surveillance and laboratory evidence established the offense without relying on Grant. 2 challenges were denied after judges found the searches lawful despite Grant's later misconduct. The outcomes frustrate people who wanted a single declaration about everything Grant had touched, but Lena understood why the courts refused one. Justice required more work precisely because it could not be done by association. The department's reforms survived their first annual audit. Manual camera shutdowns were now reviewed within 24 hours. Evidence label timestamps were automatically compared with recorded recovery times. Supervisors had to document why contradictory metadata did or did not change a complaint finding. The audit found several policy violations, most minor, and 1 search complaint that was reopened because the new system caught a chronology mismatch. Lena considered that result more meaningful than a perfect report would have been. A system admitting what it found wrong was more useful than one announcing that nothing had happened. Noah graduated from high school that spring. Lena learned about it because his mother sent a brief note through the coordinator, thanking the people who had protected his statement without turning him into a public symbol. Inside was a photograph of Noah in a blue graduation gown, holding his diploma with the embarrassed expression of someone whose mother had insisted on one more picture. Lena placed the photograph inside a drawer in chambers rather than on display. His courage belonged to him. On a humid June morning, Lena stopped at the same grocery store before court. She bought coffee, oranges, soup, and cinnamon bread. The cart corral rattled near the entrance, and for an instant her body remembered the cruiser before her mind supplied the date. She stood beside her sedan until the feeling passed, then loaded the bags without hurrying. No one watched her. No one asked her to establish why she belonged there. Later, courtroom 4B filled for an ordinary suppression docket. A young officer testified about a traffic search, then admitted under questioning that his camera had stopped recording for 90 seconds. The defense attorney raised the department's new automatic alert. The prosecutor produced the diagnostic review, showing an overheating shutdown, a supervisor's same-day inspection, and the driver's statement confirming that the officer had explained the malfunction when it happened. Lena examined the documents and ruled on the facts in front of her. The search was upheld. After court, the clerk handed her a thin envelope from the Judicial Education Office. Inside was a request for Lena to join a statewide working group on preserving digital evidence in contested searches. It was not about Grant, and it offered her no authority over anyone's case. The invitation asked whether judges, defense attorneys, prosecutors, and police trainers could build a common checklist for the first 24 hours after a disputed stop. Lena read the page once, folded it along its existing crease, and placed it inside the leather folder that had been lying on her passenger floor the night Grant stopped her. Then she carried the folder home.